Members, may I call to order the Bills Committee meeting on Inland Revenue Amendment number 3, Bill 2017. This is our first meeting and we need to elect a chairman. We know the procedures very well. Nominations and seconder. I nominate Mr. Kenneth Leung. Mr. Ronick Chan nominates Mr. Kenneth Leung. Any seconder? Mr. Charles Mock. Ms. Leung, do you accept nomination? I do. Any other nominations? If not, I declare Mr. Kenneth Leung elected ipso facto. Please take the chair. Do you think we need a deputy chairman? If not, I'll proceed with the business of this Bills Committee on Inland Revenue Amendment number 3, Bill 2017. Welcome to you, Mr. Christopher Chung. We can now invite the administration to come in. Please invite the administration team to come in.
Go through 埋封信我睇到，但唔係好 relevant。得係點啊？排隊走來走去，咁快排隊，好好啊，郭榮鏗。
Okay, Mr. Dennis Kwok, you have raised your hand to stand in the queue, maybe 5 to 10 minutes each.
10分鐘啦，好唔好啊，郭榮鏗？唔使咁耐。
Mr. Kwok, I'll give you 10 minutes, all right?
唔使限時，其實不過我都大概係10分鐘到咯，大概10分鐘到。
I think I'll take about 10 minutes.
黎生係咪咁樣？等埋。佢講咗話，佢同嗰邊講咗話會過嚟，等一等。好，我等一等佢。得。我諗啊，黎生。
I think Mr. Andrew Lai has to come from another meeting. He is talking about creating a post. He is at the establishment subcommittee, so we'll wait for him. Please bear with us. Now he's here.
好啦，歡迎各位政府嘅。
Welcome to you, officials, and welcome to you, members. This is the Inland Revenue Amendment number 3, Bill 2017. This is the first meeting of this Bills Committee. I'll ask Mr. Lai, Deputy Secretary for the Treasury, to introduce to us the bill, please. Mr. Lai, over to you. Thank you, Chairman. Thank you, Chairman and members, for taking part in this Bills Committee. I will say in brief what we are doing with this bill. The important thing is about international tax cooperation. In recent years, the international community has been combating cross-boundary tax evasion and also protection of tax revenue for different countries. That is why the OECD has proposed a series of cross-boundary taxation programs. In 2014, it proposed an automatic exchange of tax information. Together with other 100-odd countries and places, Hong Kong is a part of this effort, and we thank members of the last session for approving an amendment to the IRO so that we have a framework to start the work. And in simple terms, according to the OECD, the standards set, financial institutions would be asked to collect information from account holders who are tax residents outside Hong Kong, and in a specific form, the information should be furnished to the IRD, which will furnish the information to other countries after the exchange agreements are signed. This is what is being done internationally. In taking forward the program, I can tell members that in Hong Kong we have adopted a unique approach. For the 100 places or countries in the world taking part in the automatic exchange of tax information, most countries have taken part in a multilateral convention. They would sign this multilateral convention and they will be able to exchange information with other countries. But Hong Kong has not signed the multilateral convention, but we have preferred to go for bilateral competent authority agreements. We prefer to consult and negotiate with each tax jurisdiction. And secondly, we have different financial institutions in Hong Kong because in overseas countries they adopt a wider approach. They would get information of tax residents of all countries all over the world. But in Hong Kong, we only request financial institutions to collect information listed in our IRO and which will sign bilateral exchange of information agreements with us only. Why are we doing this? Because we have listened to members and also the stakeholders in the financial sector. We are of the view that if we move too fast, the compliance burden of FIs will be too heavy, and there will be pressure to be borne by FIs, and this may affect our competitiveness as a financial center, and that is why we have gone for the BCAA arrangement. Last year, some members also took part in the other amendment bill committee. We put UK and Japan in our schedule, and starting from 2018, we can start to exchange information with them. In the interim, we are taking forward other bilateral agreement negotiations, and as we have stated in the paper, we have already achieved progress. Together with 11 jurisdictions, we have already signed BCAAs. As of this moment, since we have signed a small number of BCAAs only, and since we have a unique approach in collecting information, the OECD and the UE has expressed information or an opinion on our approach. They say most countries have signed the multilateral convention and they can exchange information anytime, but you are moving only step by step and you are going for bilateral agreements. And then there is another concern. They say the FIs in Hong Kong do not collect tax residence information at once, and we only comply with the lowest requirement in the law, and that is only when the countries are in the schedule to our ordinance before FIs have to collect information of those tax residents. Of course, the law also agreed to allow them to adopt a voluntary approach. And that is why the EU and the OECD have said that in the middle of the year they will do an examination and look at all the places and countries taking part in the AEOI arrangement to see whether the progress is satisfactory. If someone moves too slowly or if the situation is unsatisfactory in any way, they will be listed as non-cooperative tax jurisdictions and these will be sanctioned. And that is why we think if we continue with this pace and if we are listed as a non-cooperative tax jurisdiction because we move too slowly, it will be a very big risk, and that is why we are changing our way of doing this. And in this bill, we propose that, as I said, we used to say only countries or places which have signed BCAAs with us would be listed in the schedule and FIs would have to collect information of those tax residents. But now we say that for those countries who have signed BCAAs or who will sign BCAAs will be listed, and that is why we have now 72 names added to the schedule. And members may ask, how did you come up with this list of 72 countries? Well, our consideration is simple. We in fact considered that all the 100 countries in the multilateral convention can be listed in our schedule, and that would be the best way to go about it. But if we change from 2 to 100, some FIs may find the compliance burden too big, and especially when it comes all of a sudden. To be pragmatic, we are trying to minimize the extra work, but at the same time comply with requirements of OECD and EU. And that is why we are going to include 3 types of countries. One, those who have already signed BCAAs with us, and they are always there. And secondly, the 28 member countries of the EU, because the EU has said very clearly if they can't have exchange of information with all 28 countries, then that particular country or place will be listed as a non-cooperative jurisdiction. And also, those who have expressed an interest to OECD in signing a BCAA with Hong Kong. These 3 types of countries would be places and countries which will be signing BCAAs with Hong Kong in the short term. And it would be very reasonable for if FIs to be requested to collect information of those tax residents. We hope members can support this amendment bill. So that our list of reportable jurisdictions would be much expanded, and this would satisfy the requirements on Hong Kong to comply with international standards. I think I will stop there, and I will be happy to take questions, and we'll be happy to take those questions together with the IRD. Thank you, Mr. Lai. Before we ask questions, please note that in your folder there are 2 papers. One, it is CB bracket 1 A64 bracket 01. It is a letter from our assistant legal advisor to the administration, that is FSTB, dated the 3rd of April 2017. Another paper is CB bracket 1 864 bracket 02, which is the administration's reply, that is from the FSTB to our assistant legal advisor, dated the 7th of April. Legal advisor, would you like to let us know your view on the bill? And then I will ask the Bureau also to respond to your questions. Thank you, Chairman. My letter is about 3 aspects. Number 1, the scope of reportable jurisdictions and the definition of reportable jurisdictions. This has been changed in this bill. The first requirement, that the reportable jurisdiction should be removed from Section 49(1) capital A. I'd like to ask for the legislative intent. Is it that you would like to widen it so that later on when we have the multilateral convention, this will be facilitated? Secondly, the main change may affect taxpayers' privacy and confidentiality of the information exchanged. Number 3, we are aware that the IRD would receive tax information from FIs, and then when agreements are signed with other jurisdictions, the information will be furnished, and there may be a very long period of time in the interim. And I was asking about privacy protection. These are the 3 points. Thank you. Okay, those are the 3 questions. Mr. Lai, would you like to respond to those? Thank you, Chair. On those 3 points raised by the ALA, we have given a brief response. And first, scope of reportable jurisdictions. It is correct that the previous legislative arrangement is that IRD has to sign BCAAs with individual jurisdictions before the name of that country or jurisdiction would be put into the schedule, and then the financial institutions would have a legal responsibility to collect information. But now, this process is too slow, and we have got only 11 agreements signed, and we will not be able to comply with the progress required by EU and OECD. Sorry. Are you talking about AEOI? Yes. In the schedule, After the bill was amended last year, there were only two countries, Japan and the UK.
And in order to ensure that the AEOI network is expanded and to collect information earlier, well, the OECD and EU got the idea that we're dragging our feet. So the later we leave it for negotiation, the FIs will collect information later. So there is a chance, there is a concern of data loss. And in order to allay the EU and OECD's concern, apart from applying this to those who have bilateral conventions, we also include the list of countries that have indicated an intention to sign such conventions in the schedule. And starting from the 1st of July, FIs will collect information related to 74 jurisdictions. So when there is a need to get the information, at least there will be information collected for the second half of 2017, which complies with the requirement of the OECD. We understand members are very concerned about confidentiality and privacy of data subjects. I can tell you that this bill does not touch on that, because we only require FIs to collect information on tax residents. The scope will be expanded. However, the mode of exchange of information and the mechanism remain the same. We will have to first sign bilateral convention with the jurisdiction, and when all the safeguards are in place, then information exchange will take place. We will not, without these in place, exchange information. In the legislative amendment of the principal legislation last year, there was a mention about poor performance of data protection of certain jurisdictions and what Hong Kong could do. We might have signed bilateral treaties with a certain jurisdiction. If certain jurisdictions have problems with data protection, then our IRD will talk with them, and if the situation does not improve, we will terminate the exchange of information. That's already included in the principal legislation, and this part has not been changed. IRD requires FIs to, starting from the middle of next year, furnish information to the IRD annually, so that the IRD will be able to exchange information when necessary. We think this is in order, because the information system of the IRD is of a high level of security. When the OECD visited Hong Kong, they have given recognition of data protection and also the security level of information in Hong Kong. We have the Dennis Kwok, Christopher Cheung, and another member. Let's start with Mr. Kwok. In the marked up copy, you said that you will amend the definition on interpretation of reportable jurisdiction. You have deleted the reference of section 49 bracket 1A. You said that there are 100 jurisdictions who participated in the OECD AEOI Global Initiative. Previously, section 49 bracket 1A empowers the executive in council to decide what is a reportable jurisdiction. Now you have deleted the reference of section 49(1)A. You only refer to column 1 of part 1 of schedule 17A. Is there anywhere in the provision that touch on under what circumstance will a jurisdiction be included as a reportable jurisdiction in the schedule? Anything about criteria for a jurisdiction to be included in the schedule? Thank you, Mr. Kwok, for the question. There will be 72 new jurisdictions included in the schedule. There are 3 considerations. First, 28 member states of the EU. Second, are those who have signed bilateral conventions and also AEOI treaties. That is about 42 jurisdictions. And also jurisdictions that have indicated an interest to exchange information with Hong Kong from the OECD. So out of the 3 groups, there are some overlapping jurisdictions. All in all, there will be 72 new jurisdictions added. And that is the consideration in the compilation of the list. We delete section 49 bracket 1A. Previously, the framework contains minute detail in the regulation. That I understand. I did not say that it's a problem to delete section 49 bracket 1A. You want to think out of the box, but still you have to make it clear in the law, setting out the circumstances, because in the future there may be further additions. So based on what criteria will you add more jurisdictions in the schedule? In the legislative paper, you said that, well, if a jurisdiction indicates to the OECD that they would like to participate in the AEOI treaty, then it will be added. If country A says next year said that they would like to join, then they will be added. But you have to state in the provision based on what reason or what criteria that a name is added. That is something we wanted to be included in the law. I understand Mr. Kwok's concern. Your understanding is right. There are currently 100 jurisdictions participating in the AEOI. And so far, over 70 of them have indicated an interest. We don't rule the possibility that in the future there will be more showing an interest. Perhaps they would like to start in 2018 or 2019. And when that happens, we will come to the LegCo to amend the list in the schedule by adding new names. So your line of thinking is that there is no need to make it so clear in the principal legislation. Every time there is an addition, you will come back to the LegCo and amend the subsidiary legislation to amend the schedule. So there is no need to state in the principal legislation the list of names. In the principal legislation, you said that there will be legislation to include in the list of reportable jurisdictions when they have expressed an interest to the OECD. In this case, you don't have to constantly amend the schedule. When a country indicates an interest to OECD to participate, then it will be automatically included in the schedule. And instead of this approach, you would rather amend the subsidiary legislation every time a country expresses an interest. You don't think that is onerous or cumbersome? Mr. Kwok's suggestion is indeed a very good one. If I were to choose, I would choose that. There are 2 considerations for us. I don't know whether members would like to look into that. At the beginning, when we set the principal legislation, there was an indication that that LegCo should be involved when there is an addition in the legislative amendment exercise. Well, we have to speed things up because we do not want to be included in the non-cooperative tax jurisdictions. We would like to reduce doubts to a minimum, and we would like to keep the amendments to a minimum as well, so that members will find it easier to accept. When it comes to reportable jurisdiction, it means that, they are jurisdictions with which Hong Kong will conduct AEOI in column 1. But that is also jurisdictions that has expressed an interest to AEOI to participate in the OECD to participate in the AEOI. I just wonder whether you should write it in to make it clear. In the future, when you come back to add names, the principle is that these jurisdictions have expressed an interest to participate in the AEOI. Well, as part of the answer, can you give us a letter to say that the 70 jurisdiction in Schedule 17E, I think in the future it will be negative vetting. When you come back to add new jurisdictions, well, from what we can refer to past records. Then members would know that it will be done based on the 3 criteria. That's just my suggestion for your reference. Thank you. I ask members to refer to the legislative brief, paragraph 9. We have set out the 3 categories. We don't mind, and we would send another letter in response to members' request to set out the policy. Well, a member specifically referred to this question, so I would like to trouble you to give us a letter in response to Mr. Dennis Kwok's question. And then the Bills Committee will give you a formal reply, so that in the future, members scrutinizing future legislation will find the basis easily. Mr. Kwok, in the future, when you want to add a name, you will come back to us and you will follow the usual procedure of negative vetting. We may set up a subcommittee to ask you questions. And if you adopt the same basis, say for example, these jurisdictions have expressed an interest to the OECD to participate in AEOI, that's why they are added. There won't be any other circumstance under which you will add a name. Can you say that? The understanding of Mr. Dennis Kwok in relation to the operation is perfectly correct. And if you ask me now, based on what we consider whether to add a jurisdiction, so far we can only think of these 3 reasons. Anything else, Mr. Kwok? No? Mr. Christopher Cheung. We see that OECD is quite domineering, quite bossy. Originally, there were only 2 jurisdictions, UK and Japan. Well, if I were an FI, I would only have to ask 2 jurisdictions, and now all of a sudden I have to ask questions in relation to over 70 jurisdictions. Of course, once we've signed a treaty, we have to do it. Is there more publicity? Well, some customers might think now you have to ask questions related to over 70 jurisdictions. You have to ask me information about my assets. So would you enhance or strengthen your publicity to say that this is the decision of the government and it's not brokers making things difficult for customers?
Secondly, how do we relate with the mainland? Is the mainland a party to the multilateral convention? If that's the case, does it mean that Hong Kong automatically has an agreement with the mainland, so we have to exchange information. Mr. Lai, thank you, Chairman. Thank you, Mr. Zhang, for the question. We thank Mr. Zhang for your accommodation and understanding, because this is so-called international volunteer work, and we know it is making life not so easy for the sector. Mr. Zhang, your proposal is a good one, and we'll follow it up. In January this year, we formally launched the AEOI program. We did produce APIs and posters, hoping to allow the public to understand more this program. But I must stress that if local residents do not have any tax identity outside Hong Kong, they are not affected by this program. But I agree with your observation, Mr. Zhang. There were only 2 reportable jurisdictions last year. Now there are 74. It's indeed a big jump. If the bill is endorsed by the Legislative Council later, we will update our API to let the public know that starting from July this year, FIs have to collect information of tax residents of 74 jurisdictions. I'd like to say that Hong Kong residents usually are not tax residents of another jurisdiction. But is it that brokers have to ask? Should we say to our customer, are you a tax resident of another jurisdiction outside Hong Kong? We have to ask that question, right? Is it that we have to ask each and every customer, or we can ask them just to tick or check the boxes against the countries on paper? Whenever we open an account with the customer, I think we have to explain the situation to them. Who will answer the question? I will start, and the ILD colleagues can add. We are following the common reporting standards of OECD. If you are dealing with a big customer or a new customer, you have to exercise due diligence to understand the tax identity of your customers and then follow the procedures to collect information. This is what you have to do basically. Maybe Mr. Chiu can add, Deputy Commissioner for ILD. Mr. Cheng's question can be answered like this. All FIs in Hong Kong have to exercise due diligence. In other words, whenever you have a new customer, you have to let them fill out a form to state whether they belong to any tax jurisdiction. And also the tax file number. This is my concern. When you do not mention the names of the countries, say, if I only ask about certain countries, then the customer will not be able to pinpoint a particular country, say Switzerland. Originally, we only had 2 countries, Japan and the UK. It's very easy to pose the question, either yes or no, right? But there are 72. And if you just ask people to fill a form, and since you do not pose an actual question and the customer does not fill in a particular country, then who will be held responsible? Or should we write out all the names of the 72 countries? Chairman. Normally speaking, the FIs have their own responsibility to exercise due diligence, but it is not that you have to ask about each and every country. The only thing to watch out for is that your information at hand should not be markedly different from the information you are collecting. And the FIs will have to exercise due diligence to check the status of your customers to see whether they belong to another tax jurisdiction. Will this be set by the ILD or the SFC? Who will watch over the due diligence work of FIs? Chairman, I will take the question. The due diligence standard is an international standard. In 2016, in IRA number 3 bill, the due diligence procedure has been entrenched in local laws, and they reflect international standards. As I was saying, FIs have the responsibility to do due diligence, but they just have to comply with the international standard. In other words, if you do it in a reasonable manner, then that will suffice. You don't need to act like a detective and go to the bottom of everything. That is not the requirement. The due diligence requirement is actually complementary to the AML and KYC arrangements. In fact, the information you should get should be the same. Mr. Cheung, my second question is about the mainland. Is it that the mainland is already an AEOI partner of Hong Kong? Mr. Lai. Chairman, I thank Mr. Cheung for his question. The mainland has taken part in the OECD arrangement. It is one of the 100 places or countries going for AEOI. And the mainland has also signed the multilateral convention. So it is exchanging information with other countries under that multilateral convention. But as of this moment, we have not taken part in the multilateral convention, and we are signing BCAAs with different countries. So in the past few months, the IRD has focused on negotiating with the 37 confirmed AEOI partners of Hong Kong and also another 7 in order to negotiate BCAAs with them. And these countries include China, include the mainland, and the negotiation is going on. Mr. Cheung. If Hong Kong and China will become AEOI partners, I think you need to inform us as soon as possible when a date is available. Because as you know, we always have exchange with the mainland, and maybe a large group of people will be involved. Any supplement, Mr. Lai? Chairman, we understand Mr. Cheung's concern. As always, once we have signed a BCAA with any country, we will issue a press release. Especially, as Mr. Cheung was saying, if we should sign a BCAA with the mainland, and if FIs would be more affected, we will inform them. Well, I believe if you sign the BCAA with the mainland, I think you really need to step up publicity, because there is so much economic and financial exchange between Hong Kong and the mainland, and many FIs will be affected. A press release or a notice issued to FIs will not be enough. If indeed there will be AEOI with the mainland, I really think you need to do very much publicity indeed. Mr. Cheung, you still have time. I have finished with my questions. Mr. Ronick Chan. Thank you, Chair. I have a few questions, please. First, I'd like to reflect the views of my constituents. This time around, the administration is deciding on 72 countries according to the 3 principles. Some members of the sector have asked whether the number 72 can be reduced for the first stage. About the 3 criteria, those who are confirmed will be okay. But for members of the EU and those who are interested, should we now seek to satisfy the demand in the first instance? I'd like to know whether you have considered this point. Mr. Lai. Thank you, Mr. Ronnie Chan, for the question. We do understand that we increase reportable jurisdictions from 7 to 72 at one go, and the sector would be concerned about compliance burden and also the administrative work. We certainly understand that, and we have talked to the Banking Association to see whether this can be done in stages. As Mr. Chan said, can we act according to Para 9 and deal with A first, for example, or to deal with B and C first? Perhaps we should deal with the OECD jurisdictions at a later stage. Well, we consider that possibility, but we think it may not be feasible because The EU and OECD are two international organizations, and they have shown concern that Hong Kong is moving too slowly in implementing AEOI, and they have separately said that they will examine the Hong Kong situation this year. If they should find the situation unsatisfactory, it is possible that Hong Kong will be blacklisted. Considering the assessment and demand of these two international organizations, I think we have to respond to their assessment. If we only deal with the EU and not OECD countries, and we may be criticized as biased. I hope members will understand that we have added all the partners in the three categories at one go. I think it represents the minimum. And as Mr. Dennis Kwok was saying, we could have added all 100 countries, so we will not have to revisit the schedule again. But we know that the sector will ask questions because some countries have not even expressed an interest in exchanging information with Hong Kong. And if you ask me to collect information about those jurisdictions, that is too much work. And after considering the situation, we think this is the best balance we can achieve. Mr. Chan, second question. Usually, when banks collect information, the computer system will capture 1 year's information. But then the law says it is the latter half of 2017. So banks will have to spend manpower and time in cutting the information into half. Why don't you just go for the entire 2017? If the other side doesn't want information of the first half of 2017, is up to them. So is it an option for banks so they can also furnish information for the entire year? Mr. Lai, thank you for that view. We have received the same proposal from some FIs and we have considered it. As Mr. Chan was saying, for FIs taking part in AEOI, they have to understand that this is only not just about Hong Kong. The international organizations are dealing with 100 countries. But as I said, Hong Kong is rather unique. We are only asking FIs to collect information for countries in the schedule. But of course, FIs can choose to collect information for all 100 countries. And we understand that some FIs are very forward-looking. They have adopted the wider approach from very early. And that is they are collecting information of tax residents of all these countries, and whenever necessary, they can furnish it to the IRD. From their angle, it is easier to furnish information for the entire year. But we are demanding information only for half a year because when we consulted OECD and the EU, we told them about the Hong Kong situation. They actually asked for information for the entire year, but then we explained to them that Hong Kong is a place with the rule of law. If we need to amend the IRO and ask FIs to gather more information, and if we do it by a mandatory approach, we have to go through the Legislative Council, and we need to give time for the FIs to get prepared. So after a round of negotiation, we said we will do our best, and Hong Kong will try to furnish information for the second half of 2017. If you ask those two international organizations, they would actually welcome more information. The best is for information of the entire year to be furnished. But we were thinking about the legislative timetable and also some time for FIs to get prepared. So we said we would only promise to do our best and to get the LegCo's endorsement and furnish half a year's information. After we made that promise, we heard from some FIs saying that you now promise half a year's information, but can we give you the information for the entire year nevertheless? Because I have already done it anyway. And it is more work for us if you want us to chop up the information for you. After talking to FIs, since their proposal is such that you give an option in the amended law for FIs to furnish information for either half a year or the full year. But then we thought that this might cause unnecessary concern and confusion, because we understand this may be the best for FIs and we don't quibble with that. But from the angle of customers, the customers may think differently.
Well, they may think that negotiations has been concluded for exchange of information for 6 months only. How come that you would ask for more information than that, and then you would refurnish the information of the other half a year to overseas jurisdictions? So we would explain to these FIs so that they would understand that after striking a balance between complexity, customer concern, and also undertaking to member states, we would first cover the second half of 2017. But that is only in relation to this year. And after from 2018-19 onwards, all the information will cover the entire year. So this is a one-off exception. Just now, the IRD said that the information will be stored with the department. When jurisdictions indicate a request, then it would be exchanged. Say, for example, in 2018, information is collected. Some countries may indicate a request for exchange in 2019. So will the exchange take place in 2020 in relation to information of the previous year, even though, say, for example, information has already been stored for 2018? The IRD doesn't have to be so obedient by giving all the information. Some countries may find it difficult to exchange an equal amount of information to us because they have not stored previous information. I thank Mr. Chen for his information. We have discussed with FIs. There are two considerations. The FIs think that if you want information after second half of 2017, no problem, because we will comply with the law and store the information. But do we have to regularly furnish the information to the IRD in, say, 2018, 2019? What about asking for the information when you have received a request? We have explained to the FI that in order to ensure smooth and safe operation of the mechanism, the information collected should be furnished regularly on an annual basis, because if we all of a sudden ask you for information of 3 years ago and something is wrong with your computer and the information cannot be retrieved, then the Hong Kong government will be blamed. I did not say that the bank refuses to give you the information. It's just that the IRD will not give the information away. Say, for example, in an extreme case, in 2030, there was a request for exchange of information. And you already have information stored in relation to 2017, 18, and 19. Do you have the obligation to give the information relating to 2017, 18, 19 to the jurisdiction as per the under that request? We have to first sign bilateral or multilateral convention before the procedure of exchange of information is triggered. Given the current situation, there is a huge demand to obtain information within a short time from Hong Kong. So if we store the information and not exchanging information, the chance is low. EU has already told us that all member states would like to receive information on the second half of 2017 from Hong Kong, so we have to entertain that. And so far we have signed 11 bilateral exchange treaties. Most of the order will will be received starting from next year. My time's run out. The terms of the AEOI would state the period starting from, say, a number of years. Is that right? Yes. Mr. Yu Si-wing. Well, information provider always find the information requested sensitive. People are concerned if it's accessible to a number of jurisdictions. What if, after a country has obtained the information and the information is leaked, the administration said that, well, and in an extreme case, the AEOI will be terminated? But it means that there is an inadequate protection of data subject. Would you consider increasing the sanction? When information is transmitted, what if information is leaked? So how would it be dealt with by the Hong Kong SAR government? Mr. Lai, I thank Mr. Yu for the two questions. When it comes to protection and proper use, all these jurisdictions have expressed and concern. So whether it is the EU or the OECD, they would regularly visit different jurisdictions to look at data protection measures. Well, we are confident about the OECD, which is a sizable organization. If we are concerned about abuse of information, the same concern may be expressed by other countries. And with that, I do believe that all the places will comply with the basic requirement of the OECD to protect the information and to make proper use of it. All members have to abide by that. This is the basic obligation. What about the regular notification mechanism? Say, for example, how many cases of information leak? In 2018, that would be fully implemented for the first time. This is a new initiative. I believe that the OECD would continue to look at progress of different countries to see the level of compliance, whether it is satisfactory, and if there are problems. I believe that member states or Hong Kong would express the concern to the OECD. And in relation to IRD staff, I hope Mr. Yu will have faith in the professionalism of the IRD staff, because under Section 4 of the IRO, all tax information has to be kept confidential. We cannot divulge information of a particular taxpayer. That is our core value. We will continue to uphold that. Officers who have access to confidential information are all on a list being vetted, and they've been properly authorized, and they will follow the established procedure. We understand Mr. Yu's concerned about prudent and careful use of information. As you know that recently there was a case, information about voters have been lost, and should that happen, how would it be dealt with? So it's in relation to taxpayers' information. I understand Mr. Yu's concern. First of all, we will have to prevent accidents from happening as far as possible. So the IRD will ensure that all security measures are properly carried out, are in place. Under the supervision of the TsyB, the Civil Service Bureau, if a civil servant has made a mistake, then there will be proper disciplinary measures in place. It's not just about Hong Kong. Within Hong Kong, overseas as well. Will there be clear delineation of responsibilities? For some countries, say the US, they have a higher requirement of tax information. So aside from existing information, if they ask for more information from the Hong Kong government for reference, do they have to follow a certain procedure, or would you just outright say no? Mr. Chiu? We're talking about the automatic exchange of financial accounts information in tax matters as AEOI, and it does not apply to the US. The US, there is a FRACA, and which started in 2017, that is in relation to financial information. The requirements are quite vigorous. The requirements is similar to the AEOI. That means if it goes beyond that scope, say for example conviction or personal information, would you give that? Under the AEOI, it involves information stored of overseas tax residents of overseas jurisdictions in relation to financial accounts information, say for example balance in the annual statements and income. Next, Mr. Porter. I understand that Hong Kong operates on the safe side and is rather conservative. But for some other countries, say for example in the US, it's not. It has happened that they have abused information. We've heard about information of the leaders, of country leaders. And we can't just compare Hong Kong with the US. Would it be the case that we are very cautious, but after information has been given to the other country is not as careful? It's a good thing that we can align with international practice, but don't forget that our success, Hong Kong's success, came partly because of flexibility, and we just don't follow all the rules. Otherwise, it would be just like a convenience store. There is no room for survival. In countries like, say, the US, if they want to simplify their tax regime, we want to keep a simple tax regime. If we follow other people's rules, then it will complicate our system. We can't just blindly follow simply because we want to align with international practice. The commencement date, the EU may want us to give them the information as soon as possible, but there is no retrospective obligation. Is that right? Does it mean that we have the duty to give information retrospectively? From your answer, you weren't clear about whether there would be any retrospective effect. I thank Mr. Jie for the two questions. First, about Hong Kong's participation in the international tax cooperation treaties. Yes, overseas jurisdictions are also very concerned about protecting their tax income and to combat tax evasion. That's why they are very eager to participate with overseas jurisdictions to exchange information. So such cooperation will only increase. Of course, if we are down to us to choose, we may not choose to participate as much, but it's not for us to choose. As I've said at the outset to members, that Hong Kong's scheme is quite special. We have not participated in the multilateral convention. We have taken a gradual approach by using bilateral convention.
And also, unlike other countries, we are not asking FIs to adopt the wider approach. We only ask them to be aware of IRO and the schedule to the IRO. We always put Hong Kong's overall interest first. That is why we are going for an approach with Hong Kong characteristic. But then, after we have taken that step, we discover that 90% of the 100 jurisdictions can start AEOI next year, and then Hong Kong is always saying we are not ready. Up till the end of last year, we have only got agreements with 2 countries, and at this moment, only 11 countries. Other people can use the multilateral convention, and people can always exchange information with all the other 99 countries, and so we are lagging behind. But lagging behind, is it good or not, or bad? If people don't mind, I would very much like to adopt the same attitude. But the thing is, a few months ago, OECD and EU both expressed that Hong Kong is obviously lagging behind others in taking forward the scheme, and they showed a lot of concern about our progress. They want the member countries to fall in step with one another, and they have asked Hong Kong to catch up. And after a round of negotiation, well, at the beginning they said that we could only exchange information with Japan, and other BCAAs had yet to be signed, and they expressed a lot of dissatisfaction towards this, and they said at least you must report information for the latter half of 2017. What will happen if we don't do it? They said if not, OECD and EU would do a review to see which countries are not implementing the AEOI as scheduled or desired. These would be blacklisted and would be sanctioned. That is why in the last 2 months, we hastily put together the bill and now would like members to study it so that the OECD and EU would see our determination to follow the international conventions. We are not taking advantage of the situation. We don't want to lag behind. So we'd like to step up progress and include 72 countries in the schedule, including those who have expressed an interest to sign a BCAA with us. And FIs will now be asked to start collecting information. And then later, when we sign the BCAAs, or later on if we join the multilateral convention, we can exchange information, and the information will start from the latter half of 2017. This will be able to meet the demand of the international organizations, and we cannot wait, say, till 2020 and exchange information for 2019 only, because that would amount to us taking advantage. What do you mean by taking advantage? Sorry, Chairman, you understand we are having this conversation. I should ask a question through you, I know. I think the DS is very frank, and this may not benefit Hong Kong. We tried to be flexible, we tried to be efficient, but then we were taken advantage of. This is why the UK is going for Brexit, because they don't stand to benefit anymore after they have followed the EU's rules. Can we play it in a more smart way? Can we delay till the last moment and just do something at the very last moment? The Kyoto Protocol is not beneficial to the US, so the US is also dragging its feet. Perhaps we can be more robust and preserve advantages and flexibility for Hong Kong. After all, Hong Kong is not a tax haven. We just want to be a small city with flexibility. And we are not a center for laundering money. Why are we so anxious to do this? China has been criticized many years about its human rights records, but it's still going its own way. And in Hong Kong, people have criticized our tax system, but we are doing a good job. I would say that we should always delay till the very moment and not be scared by their demands. Chairman, you are a tax expert, but I don't think we should just play the others' games and give up our own merits. Hong Kong has no resources, And we don't want to play an international police force. But the other side may think differently. They may want to suppress Hong Kong so Hong Kong no longer is competitive. And I would sound a word of caution. I thank the DS for nodding his head while I speak. If you agree with me, we should be more stringent in studying this bill. I don't think we should just open our own laws, our own doors and welcome everybody. And a House matter, Chairman. Are we going to conduct consultation? The Oxfam has written in. But it has nothing to do with this bill. They have misunderstood the issue. But, Chairman, are we going to hold a public hearing or are we going to consult the stakeholders? Well, just a moment. We'll ask the Bureau what kind of consultation has taken place. I know you have conducted consultation, and I know FIs have been invited, and you consulted them. Yes, Chairman. Mr. Paul Chair has commented on our approach towards international cooperation. I agree with you. It's just that by a certain stage, other people are making huge demands for us to comply with, and that is why we have to do something. But, well, many countries are like that. Just tell them you don't get through the parliament. But we understand, Chairman, that this bill may mean a faster approach than some small-sized and medium-sized FIs have expected because they have to make the necessary changes to their systems. And in mid-February, we took the first instance to write to all FIs detailing to them this particular plan to alert them of the possible action we are going to take. And then in early March, we organized a briefing. Over 200 people from the sector came. They listened to us, and we also listened to their concerns. We do understand, as Mr. Ron Chan and Mr. Christopher Chung said, the sector was asking whether we could put aside certain part of the work and do things in stages, or whether we can do less. In fact, we have thought about all that. The bill's proposals are, as I said, the basic response. So EU and the OECD will not blacklist Hong Kong. This is the minimum that we should do to avoid that happening. I hope members in the sector will understand. Today, we are starting a bills committee on the bill. This is the end of April, but before consulting the LegCo, we already informed the sector. They had to make administrative and computer arrangements. So we already tried our very best to give as much time to the sector as possible. And if before the bill can be passed by the end of June, so it comes into effect on the 1st of July, then the FIs will furnish information for the latter half of 2017 only in May 2018. So more or less, they have a whole year to update and enhance their internal systems. And we have done that by consulting the sector early. And in fact, before this meeting, I had an exchange with the representative of the Banking Association, and they asked me again whether we could add the 72 jurisdictions in stages, and whether a choice can be given to FIs for them to furnish information for the entire 2017. As I was explaining to Mr. Ronick Chan, after very careful consideration, we believe even though that may be a reasonable request, it might not work this time around. Well, I hope we can have a public hearing, because the administration may consult the sector itself, but the effect of a public hearing will be very different. If members don't mind, I still hope there would be a public hearing. Okay, we have heard you. Mr. Lai. Can you comment on the readiness of the sector? And understand you did some statistics in your briefing in March as to the readiness of the sector. Many FIs, in fact, are ready to collect information of tax residents of different jurisdictions. Can you update us on the situation? Chairman, as you said, in the last session of LegCo, in the bill that was passed then, the minimum requirement was to act according to 17E of IRO and to collect information according to the schedule. But the law also allows flexibility to the FIs to adopt a wider approach in order to collect information from all customers. That flexibility has been given to FIs. So when we sought an understanding with the FIs, and Hong Kong is an international financial center, many international financial institutions are having operations in Hong Kong. And they are very forward-looking and have taken a voluntary step to adopt a wider approach. Only a minority of FIs have adopted the targeted approach, and that is to act according to our instruction in collecting information. They belong to the minority. In February, we knew that we had to expand the list of reportable jurisdictions from 2 to 72. We took the first opportunity to introduce the situation to the FIs. As of this moment, no large FI came to us to say they could not do it. Certainly, they need to plow in extra manpower and time. We know that. Any other questions, please? Mr. Ronik Chan. Chairman, I'd just like to make some remarks for the record. When the DS consulted with the sector and the banking trade, I think he did an excellent job, but to the sector, well, the DS said very clearly that it is okay for the majority of FIs, but some individual FIs had difficulty because now there are not 2 countries but 72 countries, and they had to write to customers and also adjust their internal system in order to collect information. And also they had to update the computer systems. Well, this is some kind of extra compliance cost. In the process, they hope the administration will understand. Well, they have to provide information starting from next May, but they may be doing it this way, that they furnish information about 38 jurisdictions in the first 10 days, and then for other countries in the latter part of the month. We hope the administration will be understanding towards the FIs in this regard. As Mr. Christopher Chen was saying, there may be more difficulties than expected when it comes to actual implementation. This is just for the record, please. DS, I think Mr. Chen has made a very reasonable request. In writing the law and in satisfying the demands of the 2 international organizations, we seek to give the greatest flexibility to FIs. Mr. Chen, any other questions? Well, I myself don't have too many questions. Just now, Mr. Paul Chair proposed to invite relevant organizations to come to have a public hearing. I think we can arrange that. Well, it depends whether FIs are interested. I understand the Bureau has already been in contact with the FIs. Let us just arrange for that public hearing. Now, I don't know whether many people would come, but we can do this on the 19th of May at 8:30. This is the only available slot we can identify. And we can conduct a public hearing during that time. 8:30 on 19th of May. I know some OECD people are already doing inspection in Hong Kong these few days.
The simple tax regime and flexibility is very important, but so is international obligation to other treaties and conventions. But we have to strike a balance. So on the 19th of May at 8:30, there will be a public hearing. We can still proceed with the clause by clause, unless there is significant objection. We can still proceed with the clause by clause. Any objections? Who is to do this? We use the blue bill. I ask the Deputy Secretary. We can use the English version if you have no objection. Well, first of all, I thank members and the chairman for being so considerate by expediting the scrutiny. Mr. Chiu, the Deputy Commissioner of the IRD, will take you through the clause by clause. But before that, I would like to say something. There may be some amendments on two places. First, recently the OECD said to us that they understand that we would add 72 new jurisdictions to the reportable jurisdictions list. They have given us a strong indication that another name, Turkey, should be added, because it seems that Turkey has expressed a strong interest, and Turkey is a member of G20. Well, the other 19 are already on the list, and if we leave out Turkey, then it would be quite odd. That's why the OECD told us that we may consider adding Turkey because they have expressed an interest. So we would like to add one more name. That's the first change. The second one. The chairman made an observation, and he is right. In the schedule, apart from listing out the name of reportable jurisdiction, it will also be a name. When we pass this bill, in May next year, the UK and Japan, that is the two jurisdictions in the first batch, FIs should, in the middle of next year, furnish the information of the entirety of 2017 to the IRD. For the other 72 jurisdictions, this information of the second half of 2017 will have to be furnished to the IRD next year. That's the general arrangement. Korea is different. I have to take it out because it's only a technicality. South Korea. Because South Korea is the first batch of places that have signed a bilateral treaty with us. When we talk to them, they understand that as per past practice, information of 2017 will not be furnished to them. But when we discussed with them and when we discuss with other countries, we feel the pressure coming from the EU and the OECD. So we said to the countries under negotiation that originally we would give you information of 2018. But if we have to give information of second half of 2017 to latecomers, we would not give give you less information. So we have said to them that if we have made a special arrangement to furnish information of the second half of 2017 to some countries, this arrangement will apply to the countries in the earlier batches. South Korea said to us that they are actually not interested in information relating to the second half of 2017. Those in 2018 will suffice. So when it comes to South Korea, the arrangement will be different because of the special request. That is some information background. We would like to add Turkey, and the reportable year will be different. When it comes to South Korea, it won't be 2018. The rest remains the same. So I will defer to the Deputy Commissioner. Well, before we do that, in C793, Republic of Korea. I think you're talking about South Korea. Is that right? Is that 2018? So what will be the change? 2019? 2019. So before the 19th of May, you'll be able to give us the CSA. Yes. Perhaps we can talk about CSA after the public hearing. I don't know if you have any other questions. Well, we hope to deal with all the CSAs then. So let's hear from the Deputy Commissioner. Yes. Let's start with C789. The long title. It's to amend the ordinance to expand the list of reportable jurisdictions. This is the Inland Revenue Amendment Number 3 Bill 2017. Commencement date is the 1st of July 2017. Clause 2. Well, the amendments are set out in relation to sections 3 and 4, that is, section 50A, the interpretation of reportable jurisdiction. If you refer to the markup copy, you will see that previously there were two parts, and we have taken one part out, so only one part will remain, that is, part 1 of Schedule 17A. Clause 4. Part 1 of Schedule 17E, well, it's replaced with a new table containing 74 names, including Japan and the United Kingdom. That's the end of the clause by clause. How come? Well, you've added Japan and UK because agreements have already been signed. Yes. Mr. Chan, any other questions? Yes. You may recall that yesterday when we scrutinized the bill when it comes to currency, well, the reportable jurisdiction and reporting year, if there is a chance that they will be changed, it says that authority will be given to a certain official of a certain grade or rank, and it will be done by negative vetting. This is an amendment. And I see that since there are already provisions, there is no need to specifically mention this. So, can we adopt the approach of the bill on physical currency to make it clearer. So the amendment mechanism of Schedule 17E is already embedded in the IRO. I thank Mr. Chen for his suggestion. Under the IRO, there is 50J. That is 17E, 17D, and 17C, 3 schedules. The Secretary for FST will, by Gazette, amend these schedules. And they are subsidiary legislation. We have to table. We have to go through the LegCo for scrutiny. And if we have to say add new jurisdictions in the schedule, we will follow the same mechanism, but to do it by way of subsidiary legislation. It's just that this time we don't just add 72 names. As Mr. Chiu said, that under Section 50A we will also amend the interpretation. So this is done in the form of a bill. I don't have any other questions. On the 19th, in the public hearing, I hope that members will give us names if you think they are interested to appear in the LegCo to have their say. Please give their names to the Secretariat. Well, the Association of Banks is one, and Mr. Christopher Zheng's constituent. I think there are 3 or 4 major organizations or associations related to securities and brokerage. Please give us their names and we can send them invitation letters. And I think we can adjourn this meeting. And I thank members, I thank government officials. We will continue with the scrutiny on the 19th. Thank you.